So welcome to our Fast Forest session. First up, we have Mark Gevedoni, who's going to be speaking to us about condo-specific issues with existing condo corporations. Mark?
Thanks, Matthias. So the conversation here, just in a few minutes, highlighting a lot of the issues that can arise when lending to an existing condominium corporation or resale condominium units that are the subject of your loan. It's not appropriate, this conversation, for condominium development work or construction loan for to create condominium projects themselves. This is for loans to effect repairs to common elements, to assist financially compromised corporations, or to acquire assets or units from declarants, the developers, as that may be required under the corporation's declaration and before the actual turnover meeting. A turnover meeting, just for clarity, was where the corporation has been recently constituted, the project is newly developed, the builder is the owner of all of the units, and as the units are resold to the initial buyers, critical mass and the baton is effectively conveyed over to that new board of directors. That's the turnover meeting. This will highlight the importance of ensuring that you're getting proper advice from lawyers who are familiar with the requirements under the Condominium Act and its various related amendments. A number of significant amendments have started in November of 2018 and are being rolled out pretty regularly ever since then. So it's a pretty hot situation right now. Just to be clear, there are a number of types of condominium corporations: standard condominium, phase condominium, vacant land condominium, common element condominium, and the elusive leasehold condominium. It's important to understand the distinction of these. Depending on the type of condominium itself will depend on how you are lending and what kind of security you're taking in connection with it. Questions to ask are: what are the limitations in relation to the condo structure? What are the units? Are they residential units? Are they commercial units? Are they signs? Are they parking areas? Are they lockers? Are they loading docks? What are the common elements? These are used in common with other people. Sometimes they can be exclusive common elements and sometimes they're non-exclusive common elements. But if they are a common element, they fall to the condominium corporation to maintain. What's the purpose of the loan? Are there commercial, industrial, residential units? Are they mixed? What type? That's all important in ascertaining what your loan is going to do. Always go back to the basics. The declaration, the bylaws, and the rules, they need to be reviewed and analyzed before a loan is put in place. You're trying to find out if the condominium is in good standing. Has there been a turnover meeting yet? Are there a property manager, or is the condominium corporation, the board of directors, self-managing? When was the last reserve fund study, and has the reserve fund actually been properly funded? These are critical, important questions. A status certificate should be requested so that a lot of these details can be fleshed out with a certificate that the lender can actually rely upon as accurate. Is the condominium corporation involved in any kind of litigation, whether it's through the courts, arbitrations, tribunals? That's all going to be important. Are there any special assessments that are outstanding or that are pending? How many units are in arrears? When was the last AGM? With COVID, a number of condominium corporations were able to defer or delay their AGM, but a number of them still haven't held them for unknown reasons. They could be in arrears. They could be not approving their financial statements. What is the auditor's report or opinion in connection with those statements? If a condo is not in good standing, it could create liens that will rank higher than your mortgage security. Insufficient reserves will lead to special assessments, and litigation can ruin a condominium corporation. These diligent exercise of due diligence becomes much more important as the risk will increase to an ability to realize on the loan. Being mindful of what you actually are taking security in. If the loan is for an acquisition of a unit, then it's important to take security over that unit. If it's going to be a more global use and purpose, there should be a pledge of the common expense revenues, and a PPSA registration should be taken in respect of those, as well as a GSA. All of the borrower's rights to vote should also be pledged over to the lender, and many of the standard charge terms already do that. The key point here is to understand that assessing the risks relating to loaning against a condominium corporation are significant, and they require some specialized review and advice. That's all my time, so thanks very much. Mateus, back to you.
Thanks, Mark, for that summary of financing condo-specific transactions. I know a lot of commercial bankers might not run into that every day, and when they do, questions arise. So a perfect time would be during our Q&A session to ask Mark any questions that are on your mind. Next up, we have Tim Ross, who will be chatting through financing a share purchase transaction. Tim?
Thanks very much, Mateus. Hello, everybody. As Mateus says, we're going to talk about funding a share purchase transaction, and in particular, the structuring around that transaction. And as we look at this, let's start with the parties. And it's nice and straightforward. In the top left, we have a lending bank, and so that's us. Let's picture that we're the lender. And what we want to do here is provide a debt financing to our purchaser, and that's going to enable the purchaser to acquire from the vendor the target. Nice and easy. The next thing I'd like to look at are really the objectives of the structuring exercise. Structuring for its own sake isn't particularly useful. You're always trying to solve for a particular situation or achieve a particular objective. In this case, our objectives are really straightforward. We want to fund the acquisition. As it's a loan, we'd like to take effective security for that loan. And as a part of that, we want to avoid what's called structural subordination. And that's it, simple as that. Now, structural subordination warrants a little bit of attention, so let's go on a tangent here just for a quick minute and talk about what structural subordination is. So in this other example, I've got two creditors on the sheet. We're still there up in the top left as the lending bank, excuse me, and in this case, we're funding to a parent company, but we can see that there's a competing creditor in this story, and its loan is out to the subsidiary. Now, in this case, the lending bank in the top left is at a structural disadvantage to that competing creditor. And this is something that we don't like and that we're going to try to solve for. But what's the disadvantage here? That competing creditor has a claim, and by the way, that could be a bank creditor, it could be a trade creditor, it could be a judgment creditor, it could be any other creditor that would have a claim against the same assets that we see as securing our loan at the parent level. That competing creditor's claim is going to come in at the subsidiary level, and so the assets and cash flows of this group, and that's what it's really all about, are going to be taken first to repay that loan, and the lending bank in the top left is just going to get the scraps. The structural subordination can also be called equitable subordination. That's just some legal jargon. The concept is that the creditors get paid first before the shareholders do. And as lending bank, it's really the shares in the subsidiary. That's as close as we can get to these assets in this example. So with that notion of structural subordination in mind, let's turn to what we might do about it. So we'll go back to our share purchase transaction, and we'll just very quickly see how that transaction would work. It's nice and straightforward. The lending bank is going to fund the loan to the purchaser. The purchaser is going to use exactly that same money to pay to the vendor. And for the eagle-eyed amongst you, you can see that the shares have already slipped over from the vendor to the purchaser. Congratulations, we have a happy customer. The purchaser has achieved its objective of buying this target company, and so we're feeling pretty good about the whole situation. But is the job done yet? If you look at this slide, and bearing in mind what we just looked at under structural subordination, you can see that there's room beside that target for a competing creditor to get in closer to the assets than us. There are many ways actually to solve this problem. There are two that are most common, And I'll start with the single most common solution to the problem. So as you can see, the vendor is gone, it's taken its money and run. And now we've got a nice simple situation where the purchaser owns 100% of the target. The dotted line is to suggest that we're going to amalgamate these two companies. It's a very straightforward exercise. It's a corporate act. It's really within the gift of the purchaser and the target to just get on with it and do it. Naturally, our bank documents are going to include covenants that say that this will happen promptly post-acquisition. One further note is this purchaser could be a special purpose vehicle that's incorporated just to complete this transaction. If that's your case, it's best to incorporate that entity in the same jurisdiction as the target, because that makes it easier to do the amalgamation. Not impossible in other cases, but that's kind of the best way to do it. And then quickly, we'll look at one other solution for getting our debt close to those assets. And this is what we call a debt pushdown. The way this works is that you create another loan. Now, this loan is what we call a daylight loan because it's not going to be out there for very long. In essence, the lending bank provides a new loan to the target. The target then sends the money up to its parent, typically through an intra-group loan, and then the original loan is paid off. And voila, our loan is now down right beside the assets where we like to see it. So thanks very much, and I look forward to hearing any questions in the Q&A.
Thanks, Tim, for walking us through how to structure a share purchase transaction, the financing for a share purchase transaction. Next up, we have Paul Wilson from AEL Environmental to walk us through the good, the bad, and the ugly of environmental site assessments. Paul?
Thanks, Matthias. It's my privilege to give you a little bit of background on how environmental assessments can impact lending. So maybe we can go to the first slide. The intent of this is not to give you an in-depth description of how environmental assessments work, but rather how they might affect your environment. The environmental might affect your lending. So we've chosen to give you a bit of a background on the standards and then also a couple of case studies. And we titled that The Good, the Bad, and the Ugly. The good being the standards, the bad being what happens sometimes when you do an environmental assessment, and the ugly being when things go a bit south. So hopefully you'll find them instructive, and you can certainly follow up with some questions if you've got some burning issues that you need to address at your end. If we can move to the next slide. This just gives you some background on us. AEL Environment is a niche environmental firm that focuses exclusively on site assessment and remediation. And that's the area of business that we choose to work in. So we deal with these kind of problems all the time and have effective solutions to address the issues that you might come across. If you can move to the next slide. So the good is a description of the standards that apply to environmental site assessments, particularly in Ontario, but similar standards exist throughout Canada and also in the States. So these ideas are useful no matter where you might be experiencing a lending transaction. The work is basically broken into two different phases. The first phase is one that you might be more experienced with, and that's a phase one environmental site assessment. That looks at the potential for a property to produce some risks with respect to either the property use itself or anything within generally what's considered to be a 250-meter buffer around that property. So when there's a risk that's identified, it's identified as an area of potential environmental concern. And then the point of a phase two is to actually go and take some samples of soil and groundwater and maybe soil vapor or air quality vapor, determine if those phase one potential environmental concerns actually turn into a real environmental concern because the samples show that they're above the applicable criteria. So a good outcome would be a clean phase one. or one with no areas of potential environmental concern. But even if you do find a phase one with areas of potential environmental concern, you can still have a good outcome by looking at your phase two and having a clean phase two. If we can move to the next slide. So these are the standards that that you deal with. Generally speaking, most work, in our opinion, in Ontario, particularly, is dealt by the Ontario Regulation 15304 or the subsequent versions of that. And that is called the Record of Site Condition legislation. That just happens to be the title for it, but it gives you a detailed description of how phase ones and phase twos are conducted in the province of Ontario. Now, generally speaking, if you strictly followed Reg 15304, you wouldn't have enough time to complete your transaction with respect to lending, because there's some things that you have to wait for in terms of freedom of information or public records, and a few other things that can delay it beyond the normal reach of a lending assignment. So then we come in with something that's more modified. We generally call that a Canadian standards or a CSA standard phase one, which also has an appropriate protocol. So we tend to blend those two together, trying to reach the standard of a Reg 15304, but recognizing that sometimes the timeframes don't allow you to get there. Just a quick note about what a record of site condition is. Sometimes our clients are interested in records of site condition because at the end of the day, the Ministry of the Environment gives you, let's call it a clean bill of health, or a liability statement that says they won't come back and sue you if the standards change or things like that. So you do get some indemnification from the Ministry of the Environment or the province of Ontario when you get a record of site condition, but we suggest that you use that power with extreme caution. And we'll use that, we'll provide you with an example a little bit later on in the presentation. Another note is that if you have a change in zoning, then you are required to get a record of site condition. So sometimes you'll be lending on a development project and you may find that an RSC is a requirement, and that that's not something that you can negotiate out or change. But it does give you some additional liability protection. So it's a good thing to at least consider or to think through on some projects. If we can go to the next slide. So our first case study looks at what would have been a fairly typical site. It's a manufacturing facility in an industrial park. It's surrounded on one side by a high school and on another side by a residential community, and then to the north of it is a railway spur and a municipal road, and then some industrial beyond that. Generally speaking, when we looked at the property originally, we did recommend a phase two be completed as based on the phase one, but didn't think that we'd come up with any particular problems. But to give you an idea how an innocuous site can turn into a very significant site, on this particular project, we found chlorinated solvents. There's three categories of contaminants that we deal with in environmental site assessments. One of them is metals. The second one is petroleum hydrocarbons, gasoline and diesel, and those kind of products. And the third one is chlorinated solvents or associated VOCs that go along with that. Chlorinated solvents are particularly problematic and require additional attention. So when we discovered chlorinated solvents on this site, it raised a number of red flags. We can go to the next slide. So just to give you an idea, this is what the site looks like. From an aerial view, you'll see the high school running track below. You can see the roadway and some industrial above, and the residential to the west. So again, a fairly relatively innocuous site from surrounding land use. And we've identified on this drawing some of the prior uses that would have been considered areas of potential concern. We can go to the next slide. So this is the same program. We had a minimal sampling plan when we first did our phase 2, just to look for some of those background apex or areas of potential environmental concern. We can go to the next slide. And what we found was quite a surprise in terms of chlorinated solvents. They were first identified in that borehole on the south side of the property, adjacent to the running track for the high school. We think that it wasn't the current owner of the property and the use that was there, but it was associated with a prior use, and we think that quite simply it was probably some illegal dumping out the back loading door or something like that that caused the impact. Now, to give you an idea what the financial impact of this remedial work is, this program, as part of the offer of purchase and sale, with the company and the building both being involved in that negotiation, there was a $5 million environmental escrow that was set up, and it will take something in the order of 3 to 5 years to resolve this problem to satisfaction under Reg 153 procedures. So it's pretty significant. It also had some impacts in terms of indoor air and some issues in terms of health and safety. So it was more than just a subsurface issue on this particular property. So this is just to give you an idea of how what could be fairly straightforward phase 1, phase 2 can turn problematic. And to be perfectly honest, it's not entirely unusual that you'll run into a program like this. We currently have probably 9 or 10 sites on average on an ongoing basis that fit this kind of category. So it's not that unusual. If we can move to the next slide. So this particular slide is using a record of site condition as a condition of lending. So the lender decided that because of some identified contamination, again, chlorinated solvents, that they wanted to have a record of site condition as a condition of lending, but they gave an advance on funds with a 2-year time frame to get a record of site condition in accordance with those advance on funds. The issue is that we can certainly price out how to get to a record of site condition based on existing conditions, but sometimes we don't know everything that is going on based on the documents that have been provided so far. And so there can be an escalation in that work scope and a fairly significant escalation in that work scope, and obviously the cost and the time that goes along with that. So when you use an RSC as a condition of lending, there needs to be a clear understanding on the part of the lender and on the part of the lendee that there's going to be a significant investment in terms of this process, generally, certainly in the 6 figures. So they're not to be taken lightly in terms of the negotiation. And while they provide a sure outcome at the end of the day, the process can be fairly torturous. So in this case, it looks much like the last site that we saw. There's some residential surrounding, little more industrial. But in that context, we found at the apex there wasn't enough data to support the submission of an RST to the Ministry of the Environment. And so we had to go back to the owner, who was very reluctant to conduct that work, feeling that it wasn't necessary or useful for their business. And so it led to some significant discussions on the part of the lender, the lendee, and ourselves in order to try and resolve that. So in that case, at the end of the day, we weren't able to complete a record of site condition. We did talk to the owner about some other outlets that can get you through this process that don't require a record of site condition. So hopefully these give you some very high-level background with respect to that. But we can give you a bit of a primer on what to look for in terms of your phase 1 and phase 2 work. And if we can move to the next slide. This is just kind of a summary of what to look for. Make sure you have a phase 1 and phase 2 done to the appropriate standards. We recommend Reg 150-304 with any deviations being clearly noted. Make sure your phase 1 and phase 2 is up to date. The Ministry of the Environment has set 18 months as the stale date for the use of older reports. So our suggestion is that perhaps you consider that being your stale date as well. The third thing is to make sure you have a letter of reliance by your consultant to your lending institution so that you can rely on the report that they prepare and be offered the protections that the owner would be in those cases as well. And if you really have some doubt about the quality of the report, either ask for an official peer review or look at something a little more informally. We've acted in that area for lenders in other situations as well, and that has been beneficial to them. So if you'd like to stay in contact, by all means, give us a call. So back to you, Matthias. I think that covers off our presentation.
Thanks, Paul, for your presentation on environmental site assessments. Next up, we have Alex Ross, who will be giving us a presentation on taking a security interest in intellectual property. Alex?
Thank you, Matthias, and thank you everyone for virtually attending. So first, I'm going to give you a quick overview of the different types of intellectual property so we know what we might take a security interest in. First is trademarks. And a trademark is an indication to consumers of the source for wares or services. Typically, this is going to be a word or a symbol or a logo, but it can also include the shape of the product or packaging, and in some cases, sound. Trademarks can be either registered or unregistered. Copyright protects against copying for expression in such forms as writing, music, visual images, moving images, and importantly, in many cases, computer programs. Copyright only protects the form in which an idea is expressed. It does not protect the underlying idea. In Canada, registration is optional. In the United States, you will want to register it if you choose to enforce that copyright. Industrial design, which is sometimes in the United States called a design patent, protects the ornamental but not the functional features of a useful article. These are always going to be registered. Patents provide a time-limited monopoly granted by the government for a device, substance, a method, or a process, which does include some computer software, which is found to be new, inventive, and useful. A patent application and a granted patent will always be registered. Trade secrets are information that are known only within a business, not ascertainable by others, and through which that business is able to obtain an economic advantage relative to its competitors. Trade secrets, by definition, are never registered. So when we're taking a security interest in intellectual property, what kind of documentation are we going to want? First of all, you'll want to have a general clause granting a security interest over either all of the intellectual property or possibly certain classes, like maybe only patents or maybe only trademarks. In addition to the language granting the security interests, for any intellectual property that is registered, you're going to want to set out the application or registration number as well as the title. If you are dealing with unregistered intellectual property, for example, an unregistered copyright or a common law trademark, you'll want to make sure there's enough information in the document to identify the property, or alternatively, you can register it before taking the security interest. For trade secrets, it can be tricky. You want to include enough information to identify the trade secret, but obviously without actually disclosing it, or you'll lose the trade secret protection. For trademarks, the document should expressly grant a security interest not only in the trademark itself, but also in all associated goodwill. If you don't include the associated goodwill, going to enforce that security interest may actually invalidate the trademark. When we're recording a security interest, we'll go ahead and record that in the relevant Personal Property Security Act registry as we usually would. If you've got registered intellectual property, you should also record it at the Canadian Intellectual Property Office, or CIPO for short. If there's unregistered intellectual property that's particularly important in a transaction or has particular value, you may want to require that that application be registered or filed at CIPO as a condition of the loan that you're granting. This is relatively straightforward if you're dealing with trademarks or copyright. You may also want to think about whether you should be recording in other jurisdictions as well, such as the United States. One of the main reasons we want to record at CIPO, in addition to the PPSA registry, is to avoid the practical problem. If the debtor goes to sell that intellectual property, the buyer may only search at the CIPO office and may not search the PPSA registry. If you've registered at CIPO, you may avoid having an improper transfer simply by alerting the buyer. It's also important to consider Section 49, subsection 4 of the Patent Act, which holds that a transfer of a patent that isn't recorded is going to be void against the subsequent transferee if that subsequent transfer is recorded. So that means if you don't record in CIPO and then the debtor sells it to someone else who does, you may find that your security interest is unenforceable. So I will be around later on for questions. Thank you everyone for attending, and back over to you, Matthias.
Thanks, Alex, for your presentation on taking a security interest in intellectual property. That concludes our Fast Forward session. So I'd like to thank our entire group of presenters. Now we're going to go back to Pam to continue on with our conference.